And obviously today, the focus of what we're looking at is really what do SWEP workers want to know and need to know if they are, starting up this season's SWEP provision. I appreciate SWEP provision is like often quite chaotic, and you've got a million things to worry about with food hygiene standards and health and safety and fire regs and all that sort of stuff. So I'm not trying to kind of add another layer of complexity to it, really. But I think this is the stuff I'd want to know if I was in that sort of position, because the thing with SWEPs is that you're going to be working with people who potentially struggle to engage elsewhere. So it might be that you're dealing with people who don't want to engage with other services, have been excluded from other services. And that means potentially you have a very unique opportunity to actually get them housing assistance and increase their options. So yeah, other bits and pieces worth bearing in mind at this point. I'll put some further resources at the end of the slides as well. But yeah, that's the kind of idea. So what do SWEPs do? What do you need to know to if you're working in that SWEP position? And I guess just kind of dispelling some common jargon. I'll introduce myself now just to kind of give you a bit of background for this. I've worked in the sector 20 years. I knew so little of this until about, I don't know, 8 years into my career. So I managed night shelters and I didn't know what statutory assistance even was. Didn't know anything about these kinds of definitions that we're going to talk about today. Barely knew what the council was or what its remit was. I later commissioned SWEP provisions a little bit when I worked at Bedford Borough Council. And I guess, I don't know if it's right to say this or if it's accurate to say this, but my heart still remains with kind of single homes people. So that's a bit of jargon already. Single homes people are people who don't have kids and don't have a pregnant woman in their household, so they're not automatically in priority need. So it's a bit of a clumsy term, but it is kind of a sort of legally linked term. Because my days in doing kind of street outreach and stuff are some of the best years of my career, really. I love that kind of work. So yeah, that's where I'm coming from. I'm just trying to put this stuff out there today, which is going to help people out, and I guess just make sense of some of these things, which it is such a convoluted system. It is so complicated. I guess I'm hoping that these slides will help clear up some of that convolution, really, and just kind of give you a bit of a better idea of how this all fits together, because a SWEP provision is part of a much broader ecosystem of homelessness services. Some work well together, some kind of contradict each other, work against each other, and I guess a lot of it allows councils to avoid discharging their legal duties to homeless people. So that's the majority of what we talk about in the next hour or so is going to be focusing on what those duties are, but we will also mention some of the more kind of voluntary sector provision and stuff like that as well, because it does fit into it. So that's me. We've got Shannon with us for the first part of this because, she's got better things to do, basically. Busy person. But Shannon, do you want to just kind of give a bit of a whistle-stop tour of who you are and what your background is?
Oh, no pressure. So I'm Shannon. So I co-founded Homelessness Best Practice with Mike. I also have lived experience of homelessness, including rough sleeping and other forms of homelessness. And I was a caseworker at Just Us. And I sort of fell in love with homelessness law because it's just so powerful. Like when you actually know it, it's like accessible and you don't have to be a lawyer to use it. And you don't have to sort of have loads and loads of qualifications in order to be able to get your client housed. And so that power imbalance we often see in the sector, I think homelessness law is almost like an antidote for that. So yeah, that's me. I currently work in the co-production sort of sector as well in homelessness and multiple disadvantage. So yeah, that co-production and lived experience element is also really important to me. And I bring those insights myself as well. That's me.
Thanks, Shannon. Yeah, cool. I guess it's worth saying as well that the majority of workers in the sector who use housing law day to day are not lawyers. So although it can seem a bit scary, the majority of housing officers won't be lawyers, nor will their bosses be, but it is very much this legal issue. So speaking of which, Will, do you want to have a quick intro?
Yes, hello. I'm a housing solicitor and I've been doing housing law for about 30 years now. And I specialise in homelessness law, so I'd spend a lot of time writing to councils and going to court to try and challenge negative decisions or require councils to house people who they weren't going to house. And I also do other stuff like defending possession proceedings and disrepair stuff.
Nice one. Thanks, Will. I mean, I think it's fair to say Will's probably one of the most experienced housing lawyers in the country. I don't think we're going to be too critical of councils today, particularly, but just to kind of bear in mind that working in councils when you are strapped for cash is a very difficult job. So we do have sympathy with housing officers. But ultimately, the law is the law, and I guess it's crucial that the law is followed if we're actually going to see the system work. So before we get into the legal bits, I thought it just might be worth just kind of setting the scene of what other services you may well come across. Because again, I'm not trying to insult anyone's intelligence here, but I appreciate some people starting off in SWEP provisions may not have worked in the sector before at all, or it might be they've kind of worked in sort of soup kitchen backgrounds. And this is, yeah, kind of first time that they're really kind of getting involved. So this is in no particular order, really. This is the kind of provision that it's good to be aware of. So let's start with the kind of the most basic. So night shelters. Night shelters, in many ways, are quite similar to SWEP provision, except they're all year round. There aren't so many of them as there were a few years ago. I mean, COVID, I think, killed a few off, but generally there's kind of been a movement away from this kind of model. The night shelter I worked in Bedford, old school, 5-bed Victorian house, 4 beds to a room, just unpleasant on many different levels. And so even like 15 years ago, there was kind of a move towards improving the quality of that kind of accommodation, trying to get away from shared rooms, that kind of thing. Although I think there still are plenty around like that. It's worth me saying now that if you're in a night shelter, you are still legally homeless. I will kind of come back to that a bit later on, but that's our kind of starting point. Often they're direct access. Often, you kind of turn up at 7 o'clock at night, and if there's a bed, they'll take you. If there's not, then they won't. So that's our starting point. And I guess we're kind of getting here into the idea of a staircase model, or the staircase model, because night shelters are part of that. The idea being that, if you do your time in the night shelter, you get into the night shelter, you stay there for a few months, you'll put some applications into supported accommodation. And if you play your cards right, you'll get accepted and then, move in there. And then you'll remain in supported accommodation maybe for a couple of years if it's registered. So when I talk about supported accommodation, I'm talking really here about services like the YMCA or St Mungo's, or trying to think what other kind of big organisations there are that kind of provide this kind of service. It's important to understand there's a big difference between registered and unregistered providers of supported accommodation, because councils up until now have very little control over the quality of unregistered supported accommodation. Essentially, there's a really good kind of financial model for getting a lease on a house, shoving as many people into it as possible, and calling it supported accommodation. And so there's a kind of a whole Wild West kind of scenario and kind of setting where landlords around the country kind of have realised that there's a lot of money to be made, so they do. And so actually that's really what led to the creation of the Supported Housing Act 2023, which is still not fully enacted yet. We're still waiting for some details on that. But that is really there to kind of deal with this just the poor quality of some of these projects. In Bedford, again, just kind of use that as an example. We've got a couple, maybe like 400 supported accommodation beds in total. More than half of them are unregistered, as far as I know. And essentially, if you listen to people who are living in those kind of projects, they'll say that the only support, or the only time they see a support worker, is when they're chasing them for the rent, and that's it. There's no real kind of structured support at all, really. So yeah, I think it's also probably easy to tar everyone with the same brush, because there are supported accommodation projects which do have really good asset kind of facets to them, and you've got projects like Emmaus as well, which is technically supported accommodation, but it's a little bit different, much more structured. So yeah. So yeah, that's supported accommodation projects. Their kind of shortcomings tend to be they're quite inflexible, and there's not a whole load of security of tenure. So the problem with the staircase model as a whole is that it's easy to fall off the staircase and go back to square one. So like snakes and ladders. You argue with a staff member, you have a can of drink or something, can of beer in your room, get caught, you could end up getting just kicked out back onto the streets, and then you're back to square one again. And I guess there's probably a high proportion of people, I'm not saying everyone who accesses SWEPs will be in that boat, but there's a lot of people who approach SWEPs who probably have been evicted from these kinds of accommodation at least once before, if not multiple times. I mean, Shannon, at this point, do you want to kind of come in and say anything about this? So there's more to say about later, but
Yeah, I think supported housing can be really beneficial for people, but one of the most overlooked unintended consequences of supported housing, in my mind, is the sort of institutionalization that comes with it. So lots of the time, people might go to a supported housing provider because maybe they've been found intentionally homeless and whatever, or they might actually have genuine support needs. But by the time they leave, lots of people end up with higher support needs. And actually, what's more sort of scary, I think, is people end up with support needs that aren't recognised as support needs. So that institutionalization isn't really recognised in the sector yet as sort of like a real issue and barrier to overcome. So lots of people, might have a really good routine in supported accommodation. They've got various activities that they do. All of these things that we, as a sector, we want supported accommodation to be. We want it to be purposeful. We want it to have meaning. We want to, provide that support so people get back on track with their lives. It ends up meaning that people are sort of subconsciously told that they can't cope with a normal life and they can't cope if they don't have staff giving them their post. They can't cope if they don't have staff looking after their medication. They can't cope if they don't see a worker once a week. And all of those things are sort of reinforced by things like, you have to engage if you're in supported accommodation. And lots of people will sort of get evicted for lack of engagement when actually they're just really struggling. And I think all of the, not all, but most of those rules that are put in place in supported accommodation, if you gave those rules to an adult who hasn't suffered childhood trauma, that hasn't experienced any form of homelessness, that has, a good family support network and has financial resources or whatever it might be, if you gave those rules to that person, they'd tell you to do one. I think is the real reality there. Like, and that's me framing it politely, but they'd say like, I'm not a child. Like, why that level of control and power over an individual within supported housing is really problematic because you're telling the person they can't cope, and so you're setting them up to fail whilst under this sort of like veiled, oh, we're here to help you and we're here to make you cope. And I just think we don't recognise it as much. So supported accommodation can be really beneficial, don't get me wrong. It can give breathing space to a lot of people who, say, might have had a really chaotic time of homelessness and whatever, and sort of had lots of interactions with different services that have let them down and whatever. And supported housing can be that space where you can then, access and engage in mental health services or whatever it is that person needs. But equally, when we're then looking to move that person on, I think we're not recognizing that we can cause more issues sometimes. And I think that's really, really difficult as well because it's lots of people will get to the end of the supported accommodation and go, so I could have done this 2 years ago. Particularly when they're way more settled because they've lived somewhere for 2 years, they've made it a home, they've taken pride in it, they've got pictures up, if the supported housing provider allows them to have pictures up. And then they're told, well, now you can join the housing register. That's how we're going to move you on. And they're like, but couldn't I have done that 2 years ago? So what's actually been the point of these 2 years? And so I think that's another like really uncomfortable reality is, yes, it can be good breathing space, but you are sort of asking people to pause their lives, to be a resident of supported housing, and to sort of almost pause on their rights, in terms of like having friends over. So many providers, put curfews on. So many providers say you can't have children round or you can't have overnight stays or whatever it might be. You are sort of asking someone to put pause on their adulthood. And sometimes, like, we all need a break. Do you know what I mean? We all need that sort of pause and reset and, to focus on various things. But I think sometimes it's to the extreme.
Yeah, thanks,
Yeah.
Shannon. That's cool. I mean, you mentioned a couple of things that I might just kind of pick up on. So one is that a lot of people who are homeless for the first time don't understand the system. They'll probably get told that the easiest housing route for them is to get support accommodation. And in many ways, it is the easiest route. It's the one with the least resistance to actually get into. But people are not told the implications of that on their other housing options, and it will have pretty negative impacts on other housing options. There's a kind of a logical kind of position which you could take to say that you're better off making a homeless application to a council, which is what we're going to come on to in the meat of this webinar. Because if that goes wrong, you can always come back to supported accommodation. Whereas a problem that you often see is that people move into supported accommodation, they breach a few of the rules, they get kicked out, and now there's a high risk that they're going to be found intentionally homeless, and they're now worse off than they were before they started. And they won't know this, they won't be told this when they're actually making that decision. So That's all stuff to
And
bear in mind. Oh, sorry, Shannon. Yeah.
it can become a bit like a revolving door as well. So I know so many people that join one supported accommodation and the end of their 2 years are up. So they refer them to another supported housing provider in the area. They do 2 years there, then they go back to the other place, then they go to place B, then they go to place D, and it's all just like pass the parcel. Except for we're not talking about a shiny present, we're talking about humans. And so I
Yeah.
think that's what it sort of comes back to for me is, it's a good option when the quality and the standards and stuff are there within supported accommodation. But I think I would potentially treat it as a last resort for homelessness clientele. And when I say like homelessness clientele, I mean if that's their primary concern. Obviously, you've got supported accommodation for learning disabilities and special education, and that's very, very different. But yeah, I think we just need to be careful about also what other options are in the area and, look on their stats, ask them for reviews and what have you.
Yeah. So, yeah, I mean, and yeah, what you're talking about there, Shannon, in terms of kind of moving from one support accommodation to another, actually, each time that happens, the support accommodation provider will be recording that as a positive stat. So there's a lot of stat gaming that goes on in the sector as well, which again is just makes it even harder for people to get a fair shout. I mean, at the other end of the scale, we're talking, I'll introduce here the idea of housing first. Now, housing first is an internationally used model. It's been going, I mean, I think it got set up in New York, I think almost 40 years ago, if not 40 years ago, by a guy called Sam Semberis. And when you have high fidelity housing first, and what I mean by that is there's like 5 or 6 principles of housing first, and a lot of organisations have caught on to the fact if they call themselves housing first, then they can get some money. But actually, really, they're not adhering to all the principles. So one of the main principles I think is most important is the idea that the housing that someone is provided with is dispersed and not all kind of put in a big block of support accommodation. But there are projects which will have a big block, 30 people living in a single building, and they'll call themselves housing first, but they're really not. And immediately the kind of effectiveness of that drops off. The number of positive move ons they have drops off. But proper housing first is the idea that people don't need to have any kind of they meet any entry requirements. They don't have to become abstinent before they move in. They're provided with safe accommodation now, and they're then given intense support as needed to maintain it. Shannon?
Yeah, just to come in on that, because I think I did some peer research on Housing First a couple of years ago now. And one of the biggest pros that people talked about was the fact that their tenancy wasn't linked to their support. And so I think this is really important when you're dealing with someone who has like legitimate support needs or whatever, the pressure that your tenancy has when it's linked to your support is huge. Like I can't explain it, guys. Like I live in supported accommodation currently, and when my worker texts me and I'm actually having a really full on day and I don't have the headspace to sort of talk to her right now, and I get another message the next day going, I really need you to engage with me. That to me, if I don't reply to that text, I'm imagining myself sleeping rough on a beach again. Like, which is insanity, right? Like that's an illogical, that's a catastrophization. I'm fully aware of that. But that is how people respond. Like, and I think that sort of link between the tenancy and the support is often at like tenterhooks with each other. And sort of what someone actually needs might not be what the worker thinks they needs. And I think we don't always get that balance right. Whereas I think housing first sort of mitigates that because your tenancy is completely separate to the support. You could, disengage from all services and your tenancy is still fine. Yeah.
Yeah, cool. Yeah, so housing first is a bit of a postcode lottery. Despite the fact it's research based and kind of actually works really well, the government continues to just roll out more and more pilots which show that they're successful, but it never gets that kind of wider rollout. So it may well be your area has no housing first projects at all, or it might be they've got some that call them housing first, but they're not. Next up, we've got rogue landlord accommodation. So grotty HMO type accommodation. So HMO is a house of multiple occupation, where a landlord gets a 4-bed home, converts the lounge into another bedroom, sticks 5 people in there, and makes money off each of them. Often strangers, often people with kind of coexisting issues that make it difficult to live in that sort of environment. It's interesting how the government has picked up on certain types of trauma and how HMO accommodation is unsuitable for them. So, for example, if you've been a survivor of domestic abuse, if you've been a victim of domestic abuse since your 16th birthday, you will be exempt from having to stay in a HMO. You'll get the kind of the one bed local housing allowance. I appreciate I'm using lots of jargon here, but yeah. But there's lots of people. I've seen a lot of people kind of get shunted into HMO accommodation. They feel completely unsafe. They abandon it and return to the streets, and then they're told that they chose to be homeless when really it was never a fair choice. They were never actually provided with suitable accommodation in the first place. You've then got kind of various specialisms depending on the sector. So you've got refuge accommodation, so accommodation specifically for survivors of domestic abuse, similar to night shelters in some respects, as in you're definitely still legally homeless whilst you're there. And it's meant to be a short stay, which is meant to be safe and kind of give you time just to kind of find your feet and work out what comes next. And you've got accommodation options like CAS3. I don't even know what CAS3 stands for, but it's a kind of a provision for probation, or people under probation, people who come out of prison, where they get something like 80 something days of accommodation. Just again, the idea being to give people time to find something else. Yeah, my experience of seeing how that works generally is that people get shoved into CAS3 accommodation and the workers panic when the eviction date comes up because nothing's actually been done yet. So I don't know how effective it really is. You've also got something called rent deposit schemes, or variations of that word, rent bond schemes, whatever, which are run by councils, and they can be really good. They basically are schemes where the council will guarantee the deposit and potentially pay incentives to the landlord plus the first month's rent and so on, in order to kind of have this relationship with landlords in the local sector. There's probably more to say about this here, but as I say, they can work really well. They generally won't be the worst types of accommodation, although certainly in my experience, councils do use rogue landlords for that type of accommodation. But often councils will use that option where it kind of saves them money in some way, which is their right to do. But it can sometimes deprive people of a chance of getting social housing. You've then got kind of local bespoke schemes, which are a bit of catch-all. You do kind of hear about other schemes around the country that kind of have been locally set up that wouldn't kind of meet these other models. But yeah, so just look out for them. Sometimes there might be other options available that don't fall into these categories. And then finally, we've got the statutory routes, which is what we're going to spend the rest of the webinar talking about. Right, I can't avoid using jargon here, so I apologise. The Housing Act 1996 is the overarching legislation, although the actual principles within it goes back to 1977. I say this because just to make the point that this is not new stuff. This is stuff which has been around for nearly 50 years. And there are two parts of the Housing Act 1996 which are interesting in terms of getting people housed. You've got Part 6, which is essentially how you apply for social housing if you're not homeless, in effect. And then you've got Part 7 of the Housing Act 1996, which is basically the process for someone who is legally homeless. And it gets really confusing really quickly because they use the same terminology between the two different parts. I haven't got time to talk about how that all works in principle, but because we're talking about SWEP provision today, you can guarantee people sleeping in a SWEP will be very obviously homeless. So there shouldn't really be any kind of confusion there about which pathway they should go down. This is from Homeless Link's website. So SWEP is essentially was created. I mean, first time I heard of it was like 15, 16, 17 years ago. And again, I might have actually been misremembering this, but I remember there was a case where a guy basically got frostbite and lost, kind of had parts of his feet amputated. And certainly locally, that seemed to kind of lead to this desire by the local authority to pay for some kind of provision that initially, when they set it up, it was essentially, it would kick in when there was 3 consecutive nights, which were forecast to be sub-zero. That was the kind of very strict criteria. A lot of SWEPs these days have kind of branched out a lot. So again, now in Bedford, there's basically one that runs, I think, from the beginning of November right through to the end of March, irrespective of how mild it may be. But that's what it's essentially there for. Councils don't have a duty to provide SWEP provision, as in severe weather emergency protocol, if I've not said that yet. But it's kind of seen as part of this humanitarian sort of angle. There is space within the way that it's all worded that you could, in theory, have SWEP provision in very kind of heat waves as well. It's just kind of the idea being to kind of protect people from the worst of the elements. So that's what it's there. Again, this slide here is boring as hell, but I've got to do it just because I can't help using this language. I know when Will says something, he's probably going to refer to multiple terms here, but just to kind of clear this stuff up again. Yeah, maybe it's just boring to me because I've said it so many times. I knew none of this. None of these terms were terms I was familiar with when I'd worked in the night shelter for 6 years and I was managing it. Never heard of this stuff, genuinely. Even, to understand what a local authority actually did, I didn't understand it. But in effect, a housing authority, aka a local authority, aka council, I'll generally use the word council. That is the local district council or the local council that has a housing option service. So some areas it's all unitary, so all the council services are under one roof. So Bedford's an example of that. London councils are an example of that. Whereas some areas in the shires, so to speak, they'll have a county council, then an individual district council. It's the district council, which is the housing authority. They're the ones who have the duties under the Housing Act. You then got household and applicant, who that's simply the family or the single person who is approaching a council for assistance. The duty, I mean, duty is a word which I'll give an example of quite soon. Duties are things councils have no choice how they discharge it. They have to do it no matter what. They can't say we've got no money. They can't say, anything else really. They have to do it. They have to design their entire budget so that they make sure they are fulfilling their legal duties. And there's lots of duties under the Housing Act. There's loads of duties elsewhere, Children Act, adult services, all that kind of thing that councils have to balance the books with. But it is something which is overriding. Gatekeeping is a technically not a legal term, but if you think about a homeless application as being the gateway into assistance that is owed to people, then gatekeeping is when councils either deliberately, inadvertently, accidentally, systematically deny people that right to make an application. And we're going to talk about all these terms in a bit more detail shortly. The local government social care ombudsman is the watchdog for councils around homelessness. You might have heard of the housing ombudsman. You might have heard of kind of this new law coming in about damp and mold and stuff, where there's kind of new ombudsmen being created. But it's the local government and social care ombudsman which kind of investigates homelessness issues. Acts of Parliament, I'm not going to say too much here. Housing Act 1996 is the one that matters. It has then been amended by subsequent legislation, but it is still the overarching legislation that we care about. The Homelessness Code of Guidance is the statutory guidance. It tells councils how to interpret the law, and it's the first document we're referring to here, which is actually written in layman's terms. So, whereas trying to read the Housing Act would be a nightmare, you would have no idea what's going on about it. But the Homelessness Code of Guidance is freely available, and it's essentially the rule book that councils have to follow. So, well worth checking out. Essentially, you say just Google it, the PDF will pop right up, and there's various chapters about different issues, but there's only maybe about 10 chapters out of the whole lot which you would need to be familiar with, and only 1 or 2 chapters that you'd need to really care about. So Shannon's just popped the link into the chat there. Nice one. Interim accommodation and temporary accommodation are again specific legal terms. So I appreciate that refuge accommodation, SWEP accommodation is temporary. That's not what we're talking about here. We're talking interim accommodation, which is also known as emergency accommodation, but the technical term is interim, is the accommodation you get between making an application, like on the same day, in the middle of the night potentially, through to when the council makes a final decision about your application. And then you remain in temporary accommodation until you then get properly housed. And that can be for 20 years in London. I'll make this point now because I don't make it elsewhere in the slides. The variation of housing demand is massive in England. So the average waiting time, for example, for a homeless applicant in Bassett law is 6 days to get housed. The average waiting time in Kingston-upon-Thames for a 4-bed property is 87 years. So where you apply makes a massive difference. That does not mean to say that it's pointless trying to challenge a London council. It can be done. But really, if you live in one of the more rural parts of England away from the big cities, you have got a much better chance of getting your clients housed in the near future. And then I kind of briefly mentioned these 2 parts of the Housing Act which we care about, but we're talking about Part 7 from this point in. So what is a duty? This is a massive case a couple of years ago called Oman v Croydon. Bearing in mind, Croydon by this stage was already bankrupt. So I think it was if not it was one of the first councils to go bankrupt. I can't remember if it was actually the first, but it was certainly one of them. And the council had a duty to house this particular family who had a disabled child, and therefore they needed a very specific type of accommodation for that family. And they basically said, look, we haven't got any properties. What do you want us to do? And the judges basically said, I want you to go and find accommodation for this family immediately. And if that means you need to borrow money or reinvest it or do whatever, then that's what you have to do. So I'm actually read this out because it's a good one. So the Supreme Court judges are saying here, constraints on resources are not a reason for not complying with a duty imposed by Parliament, which the Housing Act is an act of Parliament. The duty owed is immediate, non-deferrable, unqualified. The fact that Croydon may not have resources immediately available to comply with this mandatory order will reflect choices it has made in the past regarding use of its general resources. And if it does not have suitable accommodation immediately available, why should it not be expected simply to call on its general resources, perhaps by borrowing money to adapt an existing property or rent or buy a suitable property without delay to add to its stock immediately available resources and comply with the order in that way? So every time any council basically says we haven't got any money and they discharge a duty unlawfully, they make it harder and harder to actually fix the problem. So, ultimately there's not been enough housing built for 20 or 30 or 40 years or whatever. Every time someone's gate kept, you basically hide the scale of the issue and you prevent actually, the issue being solved. It just allows councils to sweep the problem under the carpet. You can only sweep the problem under the carpet for so long before, you have a really big problem. So yeah, that's the idea of what a duty is. We're now going to run through something that's called the 5-part test. Now, that's not a legal term as such, but in order to establish whether there is a duty to house someone, a council needs to work out, is that person homeless? Are they eligible, which is what this slide's about? Are they in priority need, or may they be in priority need? Again, we're going to come back to this in more detail. Do they have local connection? Although, again, that doesn't always kick in. And have they made themselves homeless intentionally? Which doesn't mean to say that they chose to be homeless. It's not necessarily saying that they intended to be homeless, but it's more about, did they do something intentionally which they should have foreseen could have resulted in them being homeless? Again, we did a webinar a couple of weeks ago, specifically picking that apart in much more detail. But technically, the first test the council should apply is the test of homelessness, but actually, pragmatically speaking, it might be easier to get eligibility out of the way first. Some councils actually look at it first, and that's not technically wrong. But eligibility is this idea of having recourse to public funds. It's not technically exactly the same as having recourse to public funds. I can't tell you what the difference is, if I'm honest, and it doesn't really matter, basically. It's relevant to SWEP provision because SWEP provision will be supporting people who, some of them do have, many of them will be eligible, most will be eligible, most will have recourse, but some won't. And that massively then changes what support you can get from your local authority. Because if you're not eligible for assistance, so it might be that you don't have indefinite leave to remain. It might be that you've just returned to the country from living in Spain for 20 years or something. If you're not eligible for assistance, the only duty the council has to you under housing law is to provide advice and assistance. And that advice and assistance might be, here's a bus ticket back to Poland, off you go. That might be the extent of it. So being eligible makes a massive difference. Now, there are a couple of exemptions to that, but I don't think it's going to come up in a SWEP scenario very often. So I'm not going to talk about it here. Now, there are some, well, I don't even know if there are these days. I'm not sure how many there are. There are some charities that provide some level of provision. So up until the Ukraine war, I know that our local Emmaus would keep a couple of bed spaces open for people without recourse, but then they kind of changed it for those kind of coming through the Ukraine scheme. I don't know what other services. 10 years ago, there was a charity called REMAR. I don't think they're still around, if I'm honest. They would take some people in. But ultimately, if you're not eligible, your housing options are severely limited. And there are no easy answers to that, unfortunately, in my opinion. Anyway, I don't know what services really can make the difference in that situation. But yeah, but that's what eligibility means. And again, feel free to ask questions as we go here. But if someone is eligible, the good news is there is a lot of good stuff available for them. And that brings us on to our next slide here, which is the legal definition of homelessness. This actually gets really interesting for many reasons. However, in a SWEP setting, it's going to be pretty straightforward. That person is either going to be otherwise rough sleeping, or if they do have accommodation with a legal right to occupy, as in they might have a tenancy, they are not occupying that tenancy for some good reason. People don't choose to sleep rough unless there's a good reason for it. And one of that reasons might be that they're being cuckooed in their home. So cuckooing, again, just to kind of avoid using jargon, is where some unsavory characters basically generally prey on a vulnerable person. They're often homeless themselves, which is why they kind of they do this. But they'll come in, they'll basically take over the flat. They'll often abuse the tenant. The tenant won't be happy with this, but they won't feel able to actually kind of push back potentially. And so oh, Shannon's got to drop out. Thanks very much, Shannon. Appreciate it. We'll see you soon. Take it easy. Um, but so cuckooing's this idea that you've got someone who's generally quite vulnerable and they are at risk of abuse in their own home. It would also apply where someone's got a tenancy, but they're at risk of domestic abuse. So it's not just limited to cuckooing. But as I say, in SWEP settings, it's going to be pretty obvious that most people will be homeless straight away. And what that means is they are, yeah, they should be making homeless applications. They should be supported to be making homeless applications. Making a homeless application is a legal process in the same way, in exactly the same way that getting divorced is a legal process. Buying a home is a legal process. You don't want to walk into buying a home unless you have a solicitor kind of checking out the small print of what's going on. Really, I'd say it's the same for this idea of making a homeless application. The problem is, of course, is that there are loads of conveyancing solicitors around the country making a big amount of money out of house sales. There is far fewer solicitors like Will out there, and therefore, actually getting a solicitor is almost impossible sometimes. It's very difficult. Will's always flat out, kind of at capacity. But that in a perfect world, that's what everyone should be doing, is they should be getting a solicitor and then making an application to a council. You're also going to have people who are sofa surfing. It's quite interesting that sofa surfing is not actually defined particularly well in the law. There's one reference to it in the entire code of guidance, and that's really not a particularly relevant one. That's actually about local connection. But sofa surfing is the idea that, although you might have a friend who is happy for you to be kipping there, it's not reasonable to continue to occupy that accommodation. So they're not housed, even though they might have a roof over their heads. I have heard recent stories of London councils telling people who are sofa surfing that they're not homeless because they have a roof over their head. That's definitely not lawful. And the same would apply for someone in a SWEP or a night shelter. I wouldn't be surprised if some council officers would say, "Oh, you've got a SWEP. What's your problem? You're not homeless." But that is definitely not the right approach. So that's the definition of homelessness. So if someone is eligible and homeless, that's good. If they make an application, if nothing else, they will get something called the relief duty, which gets very complicated. But that does mean that there will be at least some kind of plan about what should happen, what support will be provided to them. Again, it's often kind of all tick box exercises, but it is what it is. At least legally, there is some support that would be available to you. So if you have someone, if you're working with someone who you think might be eligible, you have to know for sure, and they might be homeless. Well, you're pretty sure they are homeless because they're in the night shelter, in the SWEP provision, sorry. They should be making a homeless application. So that brings us to our next kind of point, which is, what is a homeless application? It's a term you might have heard before. It's really important. I would say out of everything I train on, and I train on various bits of the law, this is the single most important thing to understand, because if you get this bit right, you massively increase the chance of your client getting the right support. If you get it wrong, then it just makes everything a bit of a mess. So you want to kind of get it right the first time. And for those who kind of interested in this stuff in a bit more detail, and you're not aware of the YouTube channel, so got a YouTube channel. One of the videos is the best way to make a homeless application. There's hundreds of videos on there now. Every Thursday evening, me, Will, Shannon, and one of Will's colleagues called Karis, we basically do a live stream as well where we take questions. But this bit is, as I say, the most important bit. If you just get this bit right, you can figure everything else out down the line. It's a legal process. What that basically means is you should be doing it in writing via email, because you can prove what you've then done. The worst thing you can do is to just roll up at a council. I mean, some councils in London don't even allow you to do that now. But yeah, if you just turn up somewhere in the customer service centre and say you're homeless, legally that should be enough, but it's not. Legally, or what actually happens generally is that you'll get told, you may well get told some kind of nonsense and get fobbed off. And then it becomes quite difficult to then go back and sort that situation out. It's much better that you do it in an email, because you're then, you got evidence of what was said and what wasn't said. So that's the kind of idea. So a homeless application is when you are approaching a local authority, and by approaching the authority, you trigger various duties by the local authority. So if we just go back to this, so this is one of the few slides I'm quoting from the Code of Guidance today. So 18.5 is the paragraph in the Code of Guidance. It's talking about homeless applications, and it says that applications can be made to any department of the local authority and expressed in any particular form. They need not be expressed as explicitly seeking assistance under Part 7, so there's no kind of fancy language you need to use, as long as the communication seeks accommodation or assistance in obtaining it and includes details that give the housing authority reasons to believe that they might be homeless or threatened with homelessness. This will constitute an application. So just to make this point, if you did walk into a customer service centre and you said, I'm staying at the SWEP, can you help me out with housing? That would provide reasons that you might be homeless or threatened with homelessness and that you've asked for assistance. So if we just go to a bit of case law, just to kind of just reiterate this, there's a few other ones which I'm not including here, but these kind of give us the headlines. So Tower Hamlets XP Furders Begum, you don't need to remember that, it's just making the point. So whether he applies to the right or wrong department or authority should not matter. It should not tell that person to apply elsewhere. The game of pass the parcel has no place in this field. And yet, probably one of the most prevalent forms of gatekeeping, or the blatant gatekeeping, is when someone goes into a council and the housing officer says, oh, you're from the neighbouring borough, you can't come here, you need to go back to your own council to make an application there. This makes the point that essentially there should be no wrong door. If you walk into a particular council, they should take you in. Yes, it is onerous, but this is designed specifically to stop people being homeless, so it's important. And then they should, if the referral criteria are met, they should refer that person back formally, not simply just tell them to go back to them, go back themselves. A few other bits kind of similarly. Another one called Arby's v Birmingham. Is apparent that the threshold for the duty of council to act under Section 184 is a low one, since it arises if there are reasons to believe the applicant may be homeless or threatened with homelessness. In the vast majority of cases, the making of the application will mean that it's difficult, if not impossible, for the council not to believe the applicant may be homeless or threatened with homelessness. And another one, just to kind of beef this up as well, Graves from XP Winchester, the burden lies upon the local authority to make appropriate inquiries in a caring and sympathetic way. So the homeless application is not triggered in 2 weeks' time when the council has time to see you. The council should be arranging its resources so that people who are homeless are dealt with immediately. And in some cases, in many cases, really, there will be other duties to accommodate them immediately. I'm just going to pause for a second in case anyone's got any questions. Or Will, if you've got anything to add in at this point.
I haven't got anything to add right now.
That's cool. So that's kind of what homeless application is. There's some other stuff which then kind of happens immediately afterwards. So once you've made the application, really the next question the council should be asking is there an immediate duty to provide interim accommodation? Now, interim accommodation is not SWEP accommodation. Interim accommodation should be much better than SWEP accommodation, given that SWEP accommodation tends to be camp beds in a big room or something. And this duty kicks in the instant there is reason to believe that a person might be homeless. Well, they're in a SWEP, so they will be homeless. So, yeah, check. They might be eligible for assistance. Okay, assuming they are, let's say they're a British national, they lived all their life. Okay, well, they're going to be eligible. And they might have a priority need. That's the way you read that paragraph grammatically. So we're going to talk about priority need in a moment, because it's going to be obvious that SWEP clients are homeless, and generally speaking, it'll be pretty obvious for a lot of people that they will be eligible. The moment they make an application to a council, what it's really going to come down to is whether or not they're in priority need. And priority need is where things start getting very complicated, unfortunately. Yeah, it'd be nice if there was a nice straightforward definition of it, but there isn't. So these applications can be made in the middle of the night to the emergency duty team. So it's not, it should be fairly common for people to ring up in the middle of the night and get a hotel the same night to get them off the streets and kind of make sure they're safe. One thing I haven't mentioned in the slides here is that it is completely legal to make an application on someone else's behalf if they give you their consent. And when I do my kind of, my casework, that's how I make an application. So I say I don't send them down on their own. I don't even go down with them. I start the application in an email, which is basically, yeah, the title of the email is "This is a homeless application." And the first things I'll address in that email is these three criteria. So I'll say, Joe Bloggs has told me that they want me to make an application on their behalf. Please see a copy of their signed consent below. They are staying in the SWEP, so I think they're homeless. They're a British national. They've lived here all their life. Okay, so they think they're eligible. They in receipt of universal credit is a good indicator of that. And then the third paragraph in, you want to basically lay out the information that's relevant to priority need. And as we're going to see, the vast majority of people using SWEP provision will be in priority needs. But unfortunately, because it's so convoluted, the definition, it becomes very easy for housing officers just to say, oh, not in priority needs, go away. And you have to be reasonably knowledgeable in order to challenge that. And, if you're, generally an average homeless person probably doesn't have a homelessness law textbook up their sleeve. They probably don't have a background in homelessness law. They are probably trusting the council to do that assessment fairly. And yet, in my opinion, it's probably the single biggest area of injustice that we see, where you have people who are obviously vulnerable by any meaning of the term, which is a kind of condition of priority need, just being told there's nothing wrong with them, and being sent away, basically. So that's this kind of really important criteria. There's only two numbers in this whole in the whole of the Housing Act you really need to remember. Section 188 is the second one. The first one is this Section 184, duty to accept an application. So, just to say a bit more about interim accommodation, this is from a big case 10 years or so ago called Edwards v Birmingham. And in that case, the judges made the point that the Section 188 threshold it's talking about here is low, and indeed clearly low by design in view of the vulnerable individuals it is intended to protect. So I'll give you some examples here about kind of how councils frustrate this law. This was an example of systemic gatekeeping with Brentwood earlier this year. So Brentwood's a fairly affluent council by the sound of it, just outside the M25, just north of the M25. Effectively, what happened was someone made a complaint through the council's procedures. They got to the local government social care ombudsman. I think what then happened is the ombudsman contacted the council and said, this person's, Mr. X is saying X, Y, and Z about what happened. And the council said, yeah, well, that's what we always do. And so the ombudsman were like, hold on a minute, that you can't do that all the time, surely. And they did a full investigation into 6 months worth of clients. And what the LGO found, that the ombudsman found, was that out of 326 people who approached the council, about 110 of them, if my maths is right, were closed prematurely. And of the ones that weren't closed prematurely, only 22 of them actually received a proper decision. So if we look at that total number, again, I'm just doing the maths on the top of my head here, that's like 7% of the total were actually treated lawfully. And one of the main things in that systemic issue was that Brentwood was saying, until you provide certain information, until you provide certain ID, until you provide certain documents, we won't even open your application. That's singularly not lawful. There is no requirement in Section 184 to provide certain documents. And so, yeah, and what it basically meant was the most vulnerable people, the people with the highest support needs, the ones who were kind of experiencing the most distress and the most chaos, were the ones who found it the most difficult to then provide those documentations. And so I would imagine that the 22 cases who did manage to run that gauntlet successfully were probably the least vulnerable of the lot. So that's an example of systemic gatekeeping. I'm going to find a way of getting these slides to everyone. So I don't know how I'm going to do that yet. I might put it on a website or something. When I publish the video on YouTube in a week or so's time, the recording, I'll put like some kind of link to the slides just to kind of make it easy. But if you just Google local government social care ombudsman Brentwood, it'll be the first thing that pops up, because there's a full report. The LGO is amazing in the sense that they publish all their reports, and you can see what the principles were at stake. So that was an example of systemic gatekeeping. Bearing in mind the housing officers involved in that probably didn't even realise they're breaking the law. It's just someone, whoever came out with that policy, the IT system just basically either should have known what the law was, or they did know and they kind of did it. They just acted unlawfully anyway. But there are certainly other examples where the council doesn't even know they're breaking the law. They're just not kind of thinking about it clearly enough. And then there's some examples here, and again from the LGO website, of a couple of single homeless people being gate kept. So in this Hammersmith and Fulham case, which was from last year, the council was at fault as it failed to offer interim accommodation when Miss X first made her homeless application, then placed her in unsuitable interim accommodation, delayed in accepting the main housing duty, and failed to properly investigate her complaint. The faults caused harm and distress to Miss X, which the council has agreed to remedy by apologising and making a symbolic payment of £2,000 to her. So when we talk about homelessness as being a legal issue, if the council breaches the law, they may well have to pay compensation. It is that kind of simple. There are so many examples of situations where people are being failed and yet they don't try and claim compensation. I know that's not what we're here to do in this webinar, but this should work. This process is designed to protect people from being homeless. Unfortunately, councils basically break the law a lot, and they kind of know that the proportion of times they'll get caught is quite a low one. So it's probably cheaper on the balance of things just to pay £2,000 every so often rather than actually follow the law properly in the first place. Another one here involving Harrow. You'll notice a lot of them involve London councils. That's not necessarily because London councils are the worst, but it's probably more because there's a concentration of solicitors firms in London, and so people are probably more likely to get the support to complain and actually be told what's gone wrong. So in this one here, again, duty to provide interim accommodation arises if a council has reason to believe someone might be eligible at homeless and in priority needs. This is a low threshold. This is the LGO talking, by the way. The charity told the council, so that a charity was supporting Mr. X in this case, and the charity told the council that Mr. X might be a victim of domestic abuse or harassment. Based on this, the council had reason to believe Mr. X might be in priority need. It is literally that low. So as a charity told the council that domestic abuse is involved or other harassment, that was enough information to trigger the duty to accommodate Mr. X. The LGO goes on to say, it should have provided interim accommodation while it made further inquiries. Failure to do so was fault. He would therefore, on balance, have been in interim accommodation for up to 2 months. Instead, Mr. X slept rough. This is a significant injustice to Mr. X, and he gets £1,200 compensation. So many of the people in SWEP accommodation will have been gatekept. They won't have known to complain. But what I found in my years of doing this is that when someone is fobbed off by a council, whilst they might not know what the law is, they do realise that something bad just happened. And I've talked about this at length elsewhere. It's surprising how often people who've been homeless describe the worst thing about being homeless as how they were treated by their local council, which might seem like hyperbole or something. It's come up so many different times. So many people have articulated that kind of thing that I believe it to be an actual phenomenon. And actually, something I've not said yet in these slides is that we need to see homelessness as an issue of injustice, social injustice. A lot of charities, when I went to the night shelter 20 years ago, it was a religious organization. A lot of the principles underpinning it was the idea that, these people have made a mistake and they deserve a second chance. I don't think that's a good way of looking at homelessness. I would now say that, the people we're generally working with haven't had a first chance yet. And what they need is not mercy, it's actually justice. It's been treated according to the law. This is kind of social justice type stuff. So I'm not saying this is easy. This isn't easy, but it is possible. It is possible for lay people, certainly outside of London, to successfully get people housed using the law. The reason I say outside London, in London, because there is so much more demand, it's probably more realistic to basically get a solicitor involved if you can. But by understanding a bit about the law, you can see where a solicitor would actually help. So whilst it might not be you that ends up kind of crossing the finish line, if you can be assessing this kind of stuff in your general assessments that you're doing, you generally are increasing the chances. There will be situations where someone does get housed because of a good bit of work you did, a couple of months ago or something. So that's gatekeeping. We're between now and 5 o'clock or whatever, although again, we're going to probably finish before that. We're going to cover a bit about priority needs and local connection and intentional homelessness as well. Now, again, it probably does happen. If you have someone staying in a SWEP who is pregnant, they need to not be in the SWEP. You need to be immediately making a homes application to the council. They will automatically be in priority needs. It shouldn't be that difficult to get them housed. Now, there are horror stories. I remember hearing a story up in Northampton, which is the neighbouring borough to me, where a lady who was pregnant was told, you're not 16 weeks yet, so there's nothing we can do. And she ended up having a miscarriage on the streets. That should never happen, but it unfortunately it does. But that's probably the most likely scenario where you're working with someone in a SWEP, where they're automatically in priority needs. Again, if you have a family turn up with children to a SWEP, they are automatically in priority need. You need to get them to a council. And then these other kind of conditions are probably, they could possibly come up, but it's probably less likely. Homeless due to disaster. So, your house there's been your flat might have been flooded, or you've got a serious fire or something in the block. It does happen, but generally speaking, people in that situation will get additional support from the council. Certainly, in my experience of Bedford Borough Council, when there's been disasters, their disaster response has actually been really good, as opposed to the kind of the everyday stuff. People who have just who are in the SWEP because they fled their home because of domestic abuse will automatically be in priority needs. That's a low threshold, low evidential threshold. You don't need lots of information to back that up, particularly if the survivor gives a credible account of what's happened, then that should be plenty to cross the line. And again, I would really hope you're not seeing this. I mean, when I went to the night shelter 20 years ago, there were 16, 17-year-olds staying there. I remember one guy, he was actually 15. He lied about his age to get in. I would really hope that sort of stuff isn't happening these days, but occasionally it will do. And I say that because I think Children's Services has got better at responding to cases of homelessness. But yeah, any 16, 17-year-old, technically, homeless application isn't your first point of call. It would be to go down the Children's Services route and get an assessment under, I think, Section 17 of the Children Act, because there'll be plenty of support available that way. And you've also got this rather sort of niche form, which is 18 to 20-year-olds who were looked after for more than 3 months between the ages of 16 and 17. But as I say, I would hope that you are seldom coming up against situations where your clients have kind of come with these characteristics. The much more likely source of priority need is going to be this concept of vulnerability. And this is the convoluted bit, which makes it very difficult to actually understand and actually prove. But effectively, there's a whole list of characteristics which would be associated with vulnerability. So physical mental health issues, disabilities, veterans of the British Armed Forces, a history of sleeping rough. So many people in the SWEP will have a history of sleeping rough. No previous experience of managing a tenancy, being in custody, previous trauma. That's kind of underpinning most of this, to be honest. Being in care, risk of exploitation, substance use issues, historic abuse, language barriers, lack of support network, other special reason. Now, some of these in themselves aren't going to be enough. So, for example, a language barrier is relevant, but it's not going to be, just because your first language isn't English, you're not going to be in priority need for that reason alone. But if you kind of combine that with other issues, then it might be something which kind of crosses the line, because it's a composite test. You don't just isolate each of these things and kind of say whether they meet the threshold. You look at it all together. But yeah, just to make this point, because I think a lot of people jump to the wrong conclusion here. So, for example, veterans are not automatically in priority need. Not every veteran will be in priority need through vulnerability. You have to show in some way, or you have to argue, not necessarily show, but you have to argue in some way that their experience of being in the forces has left them to be vulnerable in some way. And again, this kind of all screams for the question of, well, what's the definition of vulnerability? Because that definition of vulnerability within housing law is very specific. It's not something which you can apply across departments. So, for example, you might have adult services saying someone's a vulnerable adult, and they absolutely rationally, that does not equate to vulnerability under housing law. I mean, there almost certainly will be, but it's not automatic. And so when you're arguing for priority need through vulnerability, it's important not just to list these characteristics, but you need to be saying why those characteristics lead that person to be vulnerable. And that kind of brings us on to this kind of definition here. Bearing in mind, I do a whole day's training. Essentially, I kind of spend sort of 5 or 6 hours on this kind of definition now. So I'm going to try and do it in like 2 minutes. The case that we care about comes from 2017, so Paniotu v Waltham Forest. And the bit we care about actually comes from a part of the conjoined case, which is a case called Smith v Haringey, which was one of Will's cases. So congratulations for Will, because This case was it was the Smith v Harringay element of the case which crossed the line, which actually kind of gives us what we want to know. As in, Mr. Smith was found to be in priority need, whereas Mr. Paniotu wasn't. And here's the judge is explaining this. The question to be asked is whether, when compared to an ordinary person, the applicant, so an ordinary is a horrible word, but it basically means like average Joe. So someone without any of these previous issues that we've talked about. So we are comparing our client in front of us in the SWEP with a person who has none of these issues whatsoever. They're healthy and robust. They're kind of, they're resilient. And the question to be asked is whether, when compared to that ordinary, healthy and robust person, the applicant, so your client, would suffer harm that would make a noticeable difference to his ability to deal with homelessness, which the ordinary person would not. Now, as I say, I don't know if that seems easy or not. I promise you, when you start boiling it down, it's not easy because there's other moving parts to it. But let's use an obvious example of someone with arthritis. So I choose this because arthritis is something which is specifically affected by cold weather and lack of, rest and so on. And so the question, if someone's got arthritis, would be, if we were to compare our client with arthritis to a healthy and robust person, would they suffer some kind of harm that would make a noticeable difference to their ability to deal with homelessness with the ordinary person or not? So I'm sure if any one of us did a sponsored sleep out, we'd wake up in the morning with some aches and pains, sure. But someone with serious arthritis is going to wake up in the morning barely being able to move. They're not going to be able to get up very easily. And so that would clearly make a noticeable difference. A noticeable, you just notice it. If you notice it, you cross the line. It makes a noticeable difference to their ability to deal with homelessness. So someone with serious arthritis, which is affected by cold weather, can't mobilize properly in the morning. They're in huge amounts of pain. That's probably going to have a knock-on effect to their mental health. That would clearly kind of be something that would be worthy of note, as in noticeable. So that person would be in priority need. Now, something like depression is often dismissed by lots of housing officers because they hardly get any training at all. But so someone with depression, you could apply the same test to. So you're comparing your client with depression versus a healthy and robust person without depression. Would homelessness affect the depression? Probably yes. I can't imagine too many people with depression who would not, kind of have any noticeable difference if they were affected by if they were homeless. So that depression is probably going to get worse. Depression is associated with things like, struggling to manage your affairs. Obviously, things like suicidal ideation and stuff like that. It might just be that person loses hope and kind of stops trying to kind of take initiative and stuff like that. All of those things may well be associated with depression. It's not guaranteed, but they may well be. Those things would all make a noticeable difference to their ability to deal with homelessness. And there's again in the day's training I do about this one. There's a case which made the point, kind of they actually quoted from some kind of royal psychiatrist, kind of, I don't know, some document somewhere, I can't remember which one it was, and made the point that depression is often badly misunderstood because it's kind of often like just dismissed so easily. Housing officers don't realize that actually depression in and of itself could make someone cross kind of past that threshold of vulnerability and be in priority need. There's another important case called Thomas v Lambeth in 2017 again, where essentially Miss Thomas's presenting issues were really depression, anxiety, and suicidal ideation. And the judge in that case made the point that you don't even need to have extreme depression. Just, the question is, does it make a noticeable difference to their ability to deal with homelessness? The answer is yes. Then yeah, they're in priority need. But you can understand just kind of, because this is so convoluted, it gets very easy for housing officers just to dismiss stuff. They'll often just be using template decision letters. They'll often have very poor training indeed. Very few housing officers get adequate training about this sort of stuff. And they'll also have probably a boss over their shoulder trying to minimize the number of people going into temporary accommodation. So the odds are stacked against your clients unless someone is willing to stand with them and fight for them. And there may not be anyone else. It may, if you're working in a SWEP, it may be you are your client's best bet of getting a fair shout at this. So it is worth the effort. Touch wood, I have got 100% success rate as a layperson in arguing people are in priority needs because the threshold is not terribly high. It's in large part a question of what quality of supporting evidence can you get. So yeah, getting a patient summary that says the person's got depression is not going to be enough, but getting their GP to say a little bit about them and say, what do you think is going to happen to this person if they were to become homeless? Then the GP is probably going to say, yeah, well, there's clearly reason to believe they might actually get significantly worse. You basically crossed the line. So yeah, if you're interested in this sort of stuff, I mean, I'd suggest kind of coming to one of our full days, because we go into this sort of stuff in a lot more detail. But yeah, just to kind of say that, I mean, I remember I worked with a case with Will a year or so ago I won't say which council it was, but London Council, and it was someone who, we really kind of were struggling to kind of show was going to cross that threshold. I think the reason that we were able to show in the end was the risk of relapse into substance use and some common mental health issues, low level mental health issues, but that was enough when push came to shove. So yeah, that is priority needs. Loads more to say about it, but that at least kind of introduces the concept to it. And as I say, if nothing else, just understand this is not straightforward. Very few people actually understand it, I think, in the sector, unfortunately. But certainly the idea that the threshold is high is just definitely wrong. My experience, the reason people are using the SWEP is that they have vulnerabilities. Otherwise, they would be somewhere else. They'd be somewhere better, basically. So most people, if not every, the vast majority of people will be in priority need. So just a little bit of recap briefly. Those three criteria, so homelessness, eligibility, and priority need, is what triggers that interim accommodation duty. Once you kind of cross that line, some other stuff happens which you don't need to know about particularly, but only after maybe kind of a week or so into the application can the council start really talking about local connection. So as we've already kind of we haven't made the point yet, neither Section 184 or Section 188 considers local connection or intentional homelessness at all. So you may have someone who doesn't have a local connection and they are intentionally homeless. They would still be owed the interim accommodation duty if they meet these thresholds. So they might be these three things. So yeah, the definition local connection itself is not terribly difficult. You've got a connection to an area. If you've lived in settled accommodation either 6 out of the last 12 months or 3 out of the last 5 years, and or you've got close family who've lived in the area for at least 5 years, and or you've got a permanent employment in the area, which would include volunteering, by the way, or some special circumstances. The special circumstances would apply to people with rough sleeping, in the sense that it might be worth me just kind of getting the code of guidance up for this, actually. Just bear with me a second. 10.6, here we are. In the case of a person who is street homeless or insecurely accommodated, i.e. sofa surfing, or that would definitely extend to SWEP as well, the housing authority will need to carry out a different type of inquiry to be satisfied as to their normal residence than would be required for an applicant who's become homeless from more settled accommodation. If an applicant has no settled accommodation elsewhere, and from inquiries the authority is satisfied they do in fact reside in the district, as in they're in the SWEP, then they'll be normal resident for the purposes of the 1996 Act. So, yeah, often you would prove that because the person is, they may be picking up a prescription from the local chemist, and you can demonstrate that's been going on for a little bit of time. Although if you actually read that technically, you could have local connection almost immediately, in theory. I've never really kind of pushed it to its limits in my casework, but that doesn't kind of suggest there's like a minimum time, as long as you're actually residing there, as in, you maybe got your GP transferred there, you're accessing support in that district. As I say, you're getting your prescription, maybe if you're getting medication, then that would be good evidence that you have a local connection where you stand. And I mean, just to make the point, although it's not very common these days, it is technically possible to have no local connection anywhere. It was much more common 20 years ago, but because a lot of services in the country now, voluntary charities and stuff, they'll have some kind of local connection criteria as well. It's made it much more difficult for people just to kind of flip between different areas. So that's local connection. Again, there is a bit more to it, but this is kind of headlines. And then finally, intentional homelessness. So I said already, it's not that the person intended to be homeless, it's they did something intentionally, which should have foreseeably meant that it should have been obvious that they could lose their accommodation. So there are some loopholes, so to speak, if that's the right word for it. I mean, it's there by design, because just because it was a deliberate act that led you to become homeless doesn't actually mean that's enough to make you intentionally homeless. Um, that is one of the criteria. So you become homeless intentionally if all of the following apply. So this is 9.7 of the Code of Guidance if you want to find it later. So firstly, they deliberately do or fail to do anything in consequence of which they cease to occupy accommodation. And B, the accommodation is available for occupation, which it probably will be. But thirdly, C, it would have been reasonable for them to continue to occupy accommodation. So there's a number of ways this is kind of makes sense. So if someone in a SWEP, that is accommodation, but it's not accommodation that would be reasonable to continue to occupy. So you can't be found intentionally homeless because you've just been kicked out of the SWEP. What the council need to do is they need to go back to your last settled accommodation. And as I say, SWEP just can't be settled. Night shelters can't be settled. Supported accommodation could be settled, although it depends how you read it. But that's what the council's job is to do, is to basically look back, where was your last settled accommodation? Why did you lose it? But also, crucially, was it reasonable for you to continue to occupy it? And if all three of the criteria aren't met, you cannot possibly be found intentionally homeless. Again, if you want more about this, have a look at the webinar we did 2 weeks ago. It's on the YouTube channel now because we spent an hour and a half on this slide, looked at lots of cases. But the kinds of things that generally would be considered deliberate would be things like committing a crime, not paying the rent when you could afford to, committing antisocial behaviour when there was no kind of mitigating circumstances. Let's say, for example, I mean, one of the things that would mean it was reasonable or not reasonable to continue to occupy would be where you're being cuckooed. So it might be you're actually doing something illegal because you're being coerced into it, but you should not be found intentionally homeless from that kind of accommodation. Drug and alcohol issues can be mitigating factors. Mental health issues definitely can be mitigating factors. But yeah, that's probably all I'll say for today. Other than the fact that if you're in priority needs, but you're also intentionally homeless, the council has a duty to house you for about 3 months in suitable accommodation, which needs to be not a SWEP kind of church hall or something. Needs to be better than that, and that gives you a bit of time just to figure out what longer term options might be available. Cool. 2 more slides to go. Suitability of accommodation is another big area of the law, quite complicated sometimes, a lot of the time. And yeah, if you manage to get this far in the process, well done. Arguments about suitability of accommodation are potentially even more difficult to win. Now, they can be won with a solicitor. I mean, I think, Will, this would be kind of your bread and butter, really. But as a lay person, it can be very difficult to kind of challenge it. But this is where homelessness, you draw back from the individual, focusing on the individual, and you look at the systemic issues. And I'll give you some examples in Bedford. So we have been for the last, when I say we, myself, Shannon, and then John and Katie from Just Us, which is an advocacy charity here. We go along to loads of open meetings at the council, public meetings, the housing committee, the full council, stuff like that. And we raise these kinds of issues. So John at Just Us has, like a dog with a bone, has been, every housing committee has been raising the issue about the quality of temporary accommodation, what checks are done, why is there damp and mold. He got 4,500 compensation for a family recently because they were placed somewhere which is clearly, kind of riddled with damp and mold and other issues. And that has specifically led to Bedford improving. One example, which is quite a neat and tidy one, was where we asked the council in the housing committee, what accommodation do they have for a homeless person who uses a wheelchair? And the answer was, there is no provision. It's just kind of like, the luck of the night. That's clearly not an adequate answer. So they then purchased 7 wheelchair accessible temporary accommodation units to be then used. So there's kind of, there are lots of things you can do, but ultimately councils have anticipatory duties to work out what kinds of accommodation they need to have. So let's say you've got a person with an arson conviction who is, homeless. The council can't say, oh, we've got no provision for arsonists. The question would be as well, surely that was foreseeable. People come out of prison for arson convictions, they're homeless. What have you done to make sure there's suitable accommodation available for them? So there's a lot of stuff that can be done with that, but generally it's going to be a much longer grind. You can get good outcomes in individual cases, But really, that's a job that involves getting political with a small p and challenging council standards. So that's kind of it, really. Will, have you got anything to say at all that kind of I haven't kind of mentioned or would be good to mention?
Um, I think I'd just conclude by saying that this may all seem a bit overwhelming, um, and it is, and it's a constant learning experience. But the key thing, I think, like Mike said, the key things you've got to remember are the section 184 and 188. But I would add to that is that what you should always be looking for is when somebody's applied to a council is to get a letter, get a decision letter in writing from them, because the problem nowadays is that the system is so broken that people would often just get turned away with some bad advice. But the whole homelessness law is or procedure is based on the fact that the government recognised that that happens but shouldn't happen, and so they introduced this requirement to give a written decision. And if they haven't given a written decision, then they haven't processed the application, and that's unlawful. Even if the written decision is negative, at least you get a chance to see it, so you can tell they've taken the application seriously. And the other parting thought is when I say the system's broken, I mean that 30 years ago, you used to have what was called homeless persons units, which were a bit like going into a DSS benefits office, DWP benefits office, and you could go and take a seat and go to a counter and somebody would talk to you. Since COVID, most councils in London, say, have taken the opportunity to close down their homeless persons units, and it's as if lockdown never finished. If you try and go into the council and say, "Where's the homeless persons unit?" they'll look at you like you're asking for something else that died out years ago. And so that makes it really, really difficult to get an intelligent answer from a human being as to what's going on. So that's why it's important to just keep on asking for the written decision, because at least that's something you can get a grip on, rather than be sort of palmed off with either people ignoring you or giving you bad advice verbally.
Yeah,
And
that's
that's it.
cool. I mean, we regularly have people on the live stream or through the live stream who the information that we share and they get from other places as well. There's other great resources out there. Don't get us wrong. Um, that basically they're able with that information if they stick with it, if they're methodical about it, and it is, yeah, as Will just said, kind of as simple as kind of making sure the council give you something in writing, which then gives you instructions of how to challenge it. Those kind of steps genuinely do allow homeless people to fight their own battles. I mean, in most cases, homeless people are, they're kind of their own best advocates. They're the ones who care the most. And if you give them some good information, they are, you're consistently able to actually get good outcomes themselves because they're obviously kind of quite tenacious about it because it matters. So, yeah, I don't want to kind of sound too doom and gloom. I mean, there is definitely reason to be doing this stuff. It does matter, and you can get some really good outcomes. And yeah, my belief is that if you see maybe like 50 individuals or 100 individuals over the course of the winter in a SWEP, I mean, you'd be able to house dozens of them through this process. Maybe like I don't know half. I don't know. I don't want to give a too precise a figure, but it could really matter. And if you, as a SWEP worker, you're not able to kind of do that kind of legwork and that in-depth stuff, you may well be able to be part of a hub of professionals who are working together to support someone, and you will have access to useful information that would maybe, for example, support the idea that they're in priority needs. So there's a lot of reason to kind of to take this stuff seriously, and ultimately to my advice, having worked in night shelter environments, one of the biggest challenges you've got is to try and keep your head above the chaos that kind of happens every night, and kind of play that long game of what kind of outcomes you can actually be going for. So to finish, if you haven't seen us on YouTube, every Thursday night we do a live stream. There's loads of other videos as well. So yeah, 7:30 p.m. It's recorded, so you don't have to watch it live. If you ever submit a question to me via email or in some way, I will simply anonymously take it to the next live stream to answer it there, because as you've noticed, housing law is not generally kind of quick and easy to explain. It requires quite a lot of words. So yeah, check out the YouTube channel, subscribe to the YouTube channel. Follow us on Eventbrite. We're going to be doing more of these webinars. We've got one in 2 weeks, which is about everything domestic abuse workers need to know about homelessness. We've had over 100 sign-ups already. I have to limit it about 140, so you need to be reasonably quick with that one. Plus, we're looking at doing ones about, kind of criminal justice workers and social workers and mental health workers to kind of hone in on what's kind of most relevant. So yeah, hopefully this has been useful. Hopefully there's some stuff there that will kind of help you. I mentioned the Facebook group as well. There's a Facebook group we run where you can ask anonymized what if questions and get a pretty quick answer. And this link here, again, I'm going to try and figure out a way of getting these links onto the YouTube channel. I might just be able to share the actual slides in chat. That might be the best way of doing it. But basically, this is a list that Will's done on his website, which is a list of legal aid funded solicitor firms that can take cases of kind of housing cases on. Now, that doesn't mean to say it's easy to do it, because you're going to have to find one with capacity, but it's certainly a good starting point.